Good afternoon. My name is Lisa Smith. I use she, her pronouns, and I'm the Executive Director of the Washington State Microenterprise Association. We're really excited to be here today to welcome all of you to this webinar that will invite all businesses to learn more about the I-9 form and I-9 compliance and a myriad other issues. For background, the Washington State Microenterprise Association is really focused on helping the very smallest businesses around Washington with business training, technical assistance, and financing. And the way we do that is through grant making. We provide grants to nonprofits around Washington to do that on the ground work with businesses. The second part of our work is around training and technical assistance. This webinar today is an example of that work. And finally, we have and support the Evergreen BizLink, which enables every business everywhere in the state to find the business technical assistance, financing, and other resources they need to support their small business. We are joined today with two incredible partners. One is the Small Business Resiliency Network, which is a part of the Department of Commerce. And the other partner is Ugo Nicolas, who is with the Governor's Office of Regulatory and Innovation Assistance. Ugo and Jessica have been instrumental since April in helping us unravel and unfold the resources that businesses and nonprofits need to be compliant with federal and state laws around immigration. So I'd like to begin just by having Ugo introduce yourself and share a little bit about your work, and then we'll move forward with the program. Go for it, Ugo.
Thank you, Lisa. Hi, everyone. My name is Ugo Nicolas, and I'm with the Governor's Office for Regulatory Innovation and Assistance. I am the small business consultant. Today, we are partnering with Lisa to host this vital training. So one of the roles in our agency is to support small businesses navigate the regulatory process. We know that as a small business owner, sometimes there's a lot of things that you got to do. It can be costly. So we want to make sure that we're providing these resources. Obviously, the I-9s are very relevant to today because there's new updates, new changes happening all the time. So we want to make sure that you have this information available because we know that this can be costly. So hopefully you gain a lot of information from today's training, and thank you for being here.
Thank you, Ugo, for your work and for supporting this effort. We're really grateful to collaborate with you. Now to the program. This presentation is intended to strengthen small businesses and their capacity to navigate deportation and other concerns impacting their employees, their compliance with existing rules, and their ability to operate under state and federal law. We are very grateful to be joined by our speaker, Kripa Upadhyay, who's an attorney here in Washington State. And she's going to cover introduction to the I-9 form, the I-9 compliance and completion and maintenance of the I-9 form. She's also going to talk about updates to the electronic I-9 and really look at the difference between or the comparison between the I-9 and E-Verify. We're really grateful to have Kripa here joining us today. She works in a firm here in Washington with a practice that intersects immigration, corporate business law, foreign direct investment, and international trade compliance. She has expertise in guiding corporate clients and individual investors through the very complex web of laws and regulations related to immigration in the United States. And so without further ado, let's welcome Kripa Upadhyay. Thank you, Kripa. Take it away.
Thank you, Lisa. Hello, everyone. My name is Kripa Upadhyay. I am an attorney at Buchalter. We are a national firm with a presence in Seattle, as well as Portland. I am with the Immigration and International Trade team. I do a lot of work with foreign nationals and foreign businesses and foreign owners. And so I-9 compliance is a big part of my practice. I will start with a caveat that there is a lot to cover today. So I'm not going to get into all of the nitty-gritty and all of the nuances of the I-9. But I'm hoping, I'm hoping that this has been structured well enough that you walk away knowing exactly what you need to do and what you need to know in order to maintain compliance. I know that there is a fair amount of fear and trepidation about where we are in this moment. And so I don't want you to look or take this information to be, meant to scare you into submission. It isn't. It's just meant for you to have the information and the resources you need. We are at a time where immigration enforcement is at an all-time high, unfortunately, and the new, soon to be confirmed, I think probably just confirmed, head of Department of Homeland Security has made his intentions clear that enforcement is going to be his priority. And so the information presented today is with that understanding. All right. But I do want to get started because, like I said, there is a lot to cover. So I know we have a separate system for questions. I'll try to get to your questions at the end. But like Lisa said, we will also make sure to give you detailed answers so that you have that as a reference point as well post today's session. All right. So like I said, I am an attorney. I've been practicing specifically in the immigration foreign direct investment realm since 2008. So if I stutter and mutter, the brain cells are very quickly declining at this point. But so the purpose of the Form I-9, this is not something that you get to opt into, right? This is a requirement for all employers, whether you have state contracts, government contracts, you're a small 3-person entity. Anytime you have a W-2 employee, you are required to complete a Form I-9. There is a difference between the Form I-9, which is either a paper form or an electronic version of the form, and E-Verify. Either one does not substitute for the other, right? So even if you have opted in to E-Verify, because E-Verify is optional, you are still required to complete the Form I-9. It has to be completed by all new employees. If you find yourself, and we'll talk about the audit process, but if you find that you've been in operation since the 1990 and lo and behold, you were not aware of Form I-9 and you never completed one, can you now go back and complete them belatedly? Yes, but the likelihood that immigration, and particularly the Department of Homeland Security, and within that, Homeland Security investigations, is going to look upon that as a violation is very high, right? So again, just understand that completing a Form I-9 is not optional. It is a requirement, irrespective of your size. There are certain entities that are required to be a part of E-Verify, and that is if you are a contractor with sometimes state, but certainly federal contracts of federal agencies. But that the E-Verify program is something that you can opt into. The I-9 is not an optional thing, right? The I-9 consists of clearly delineated sections, and each section has its own requirements as to who needs to complete them and what information needs to be provided, right? So section 1 is essentially the employment information, employee information and verification. This is where you would see information asking you for the employee's full name, their first name, middle name, last name, date of birth, social security number, home address. And then this is also where the employee must designate what their status is in the US. Are they a US citizen? Are they a US national? Are they a lawful permanent resident? Or are they a foreign national who is allowed to work in the United States under some form of employment authorization document? Section 2 is employer review and verification. And then section 3 is really only used to update or re-verify an employee. And we will cover each of these during the course of today. All right. The most common error, particularly for small employers, and I understand, having owned and run my own business for a long time, there are a million things that you need to do any given day. You're probably wearing, 5 different hats within the same hour. So I understand that compliance and making sure that you're using the correct version of the Form I-9 is not the number one thing on your list of things to do, right? But you are required, when you complete the Form I-9, to make sure that you are completing the current version of the Form I-9. And these change relatively frequently, unfortunately, without a lot of prior knowledge or prior notice to employers, right? So the current version that if you, let's say you were to complete this today or next week or this month even, hopefully this stays the same, but the current version expires May 31st, 2027. There are two versions of the Form I-9. There is an English version and a Spanish version. For any employers outside Puerto Rico, you cannot use the Spanish version, right? Only employers inside Puerto Rico are allowed to use the Spanish version. If you are outside of Puerto Rico, you can use the Spanish version as a guide. You can provide that to your employees so they can, let's say, complete the Spanish version in English, and then you can help translate that information onto the English version. But there are then requirements that you have to complete, which basically means whoever is doing the translating has to sign on the Form I-9, that section that says you were a translator or interpreter. There is an alternative procedure for people that want to hire remote workers. So if you have remote workers, you are allowed to either have them go into a designated, let's say like FedEx or UPS or a notary public office, or if you use E-Verify, then you are allowed to look at documents online. What you are seeing on the screen right now, this is currently the version of the I-9 form that I'm talking about, right? So when I say section 1, this is what I mean. This section here at section 1 must be completed by the employee. The things you want to be careful about on this section, again, this is more for audits, right? An audit is basically where immigration comes in and says, let me look at your I-9s, and for any errors on the I-9, they will charge you a certain amount of money. And each mistake can be very costly, right? So the things you want to be careful about, for example, date of birth. This is a very common mistake. The rest of the world uses the day, month, year format. So when you ask an employee that is not from the United States or was not raised in the United States to write in their date of birth, they are very used to writing their date of birth in the day, month, year format. If that format appears on this section, that is a chargeable offense or that is an offense, that is an error on the I-9. It's not necessarily one that you will be charged for, but it will be marked as an error, right? So that's one thing to be careful about. The other is the social security number. Somebody isn't paying attention, maybe they make a mistake. It goes, one digit off, digits are interspersed, or it's left off entirely. You want to make sure that each of these fields is marked and is completed and is completed correctly. The other question that I see very often is, I do audits as well for our employers and for others. I do audits all the time. And so one of the things that I always notice when I'm doing my audits is in the last name, particularly if you have two last names, right? You cannot choose to use one of your two last names, or your employee cannot choose to use one of their two last names. They have to use the full name because that's what it asked for, right? So let's say it's, the first name is, this is the other thing I see. And the first name, if your name is Ronald, then your employee needs to put in Ronald, not Ron or Ronnie. Their preference does not matter. It is their legal name that matters, right? So if you're saying Ronald and whatever the two last names are, those need to go in. Now, if there is a suffix at the end of that, there's a junior, senior, numerals 1, 2, 3, whatever that may be, it goes last name, hyphen, second last name, comma, and then your suffix, right? So junior, senior, 1, 2, 3, whatever the case may be. But that needs to be completed. Then once you get to list section 2 is where you have to complete the documentation that the employee provided, right? I'll keep coming back to this slide as a reference point, but I want you to make sure you understand what this is. So the regulations, if you print up the Form I-9 from uscis.gov, generally what you will get is several pages, right? Because you will get this form, and as you can see, this is page 1 of 4, because the pages that come after it are the list of documents. So it'll tell you, for example, these are the documents that you can accept as a List A document or a List B document or a List C document. The other point in time where employers get into trouble and end up having to pay a significant fine is because of errors in this section, section 2. which is for the employer to complete, right? If the employee provides you, let's say, a US passport, that is a List A document. If they give you a birth certificate from the United States, that is a List A document. That is all you need. You do not then need a List B or a List C, right? But let's say they give you a driver's license. Then typically you would need a List B and one List C, right? You cannot have two List Bs. You cannot have a List A and a List B. You either use List A or one from B, one from C. And you have to document that correctly. What do I mean by when I say correctly? If it's a driver's license, right? Most people will say California driver's license because look, document title is the first field. The title of the document can be California driver's license or Washington state driver's license, right? But issuing authority has to be the Department of Motor Vehicles because that is who has authority to issue a driver's license. So same thing if you are using a US passport, right? Your document title would be US passport. The issuing authority would be the US Department of State. Or it would be US birth certificate and then Department of Vital Records, right? Because that's who issues them. So make sure that this is correct. The third thing where there are a lot of mistakes is this section down here, which says first day of employment. The requirement is that this form must be completed within the first 3 days worked. You can absolutely complete this form prior to the first 3 days worked. So let's say you're a bigger or a medium-sized employer or a very organized small employer, and you've already offered the employee or the intended employee the employment, they have accepted. There is an affirmative, there is a definite start date that you have in mind. Let's say this person is expected to start 1st of July. You can absolutely complete this form before the 1st of July, right? My recommendation to employers is that you don't do it way before, but a week before is fine. You would still put first day of employment would still be the 1st of July because that is when they intend to start the employment. But the difference between the first date of employment and today's date, which is the date that the employer or the HR person is signing this, cannot be more than 3 days apart, right? This has to be completed within the first 3 days of employment. So 1 and 2 are going to be the main parts of the I-9. You may never get to part 3. I have some employers who end up having to do part 3 very frequently, but that depends on what sort of a business you have and your turnover, right? Because remember that the I-9 form is only for W-2 employees. It is not for 1099 independent contractors. There are restricted situations in which interns may have to complete Form I-9, but normally it is only for W-2 employees. Which brings me to the third point. If you are a staffing agency and you are providing a resource to a third-party agency, but the W-2 or the wages are going to be paid by that secondary employer, then you do not have to complete the W-2, the I-9, right? But if you are a staffing company and the employee is your employee, right, you're getting money from a company that you are placing them at, and then a portion of that is going to the individual, then they are your employee. Then it is your responsibility as the employer to complete the Form I-9, right? But W-2 employees on your payroll, every W-2 employee on your payroll needs to have a Form I-9. Okay, so again, I think I covered this, but section 1 has to be completed, as I said, by the employee. Now, you can use a translator or a preparer if the employee does not speak English. And for this purpose and this purpose alone, you can use the Spanish language of the Form I-9 to use as a guide. But otherwise, even if you are using the Spanish language of the form, a Spanish version of the Form I-9, you need to still complete that section on the form where it asks for information about the preparer or the translator. But when the other thing is, to the extent that you have employees that may be on temporary protected status, that may have applied for asylum, that may be on DACA, or that may have been paroled into the US, right? So some form of immigration status that is not a green card, that is not citizenship, then the employment authorization expiration date on the document that they give you becomes very important. For your own protection as employers, my recommendation is that you calendar that date on whatever calendaring system you use as a reminder to yourself to ask the employee to provide updated employment authorization documents at least a month before the expiration of the one that you have on file, because you will need to complete a new I-9. Now, you don't need to complete the entire I-9 form. You don't need to complete page 1. You will need to complete page 2, which basically just has the re-verification, right? It says, for example, here is where it says, an alien authorized to work until, so part number 4, on section 1, where it says a US citizen, a non-citizen, a lawful permanent resident. Number 4 is an alien authorized to work until, and there is an expiration date there. So that is where you would put the expiration date. So then when that expires and you need to update it, that is when you would go to part 3, which is the re-verification. And then just on that page alone, so page 2 of 4, you would complete the new information based off of the new employment authorization document, staple that page to this page, and maintain that as a standalone I-9, right? So then your I-9 would have maybe multiple pages of page 2, where all you have is, okay, on the original I-9, this person was authorized to work until December 2025. And then they got an extension for 2 years or 3 years. And so they worked until 2028. And now we've got another extension. So it's not unusual to have multiple page 2s, but just make sure that that is something that you're paying attention to. Okay. Again, some of the most common mistakes, in addition to the date of birth being transposed from date, month, year to month, day, year. That's one thing you need to check for. Make sure that they give you their full address. 126 Anywhere Street with a city and a zip code missing. That doesn't work, right? You need to make sure all of the information is provided. And then we've already covered the names. So the hyphenated last names, and anytime there's a suffix like a junior or 1, 2, 3, that tends to get complicated sometimes for HR, but make sure that you're paying attention to that as well. Okay. Like I said, for section 2, which is where you are required to review the documents, the one thing to make sure about this is you cannot tell the employee what documents to provide. So for example, you cannot tell them, it would be really nice if you could just provide a copy of your US passport or your US birth certificate because it's easier for us that way, or whatever the deal may be, right? Typically, when you are providing employees with information about the Form I-9, my recommendation to my clients is you just provide them the list of documents and you allow them to pick and choose what it is that they want to provide you with. When they come back to you with the documents, you then have 2 choices. You have to inspect the documents physically, right? For those of you that have employees coming to your site, you have to inspect the documents physically. The choice that you have is whether you then want to keep a copy of those documents or not. You are required to keep a copy of the Form I-9. You are not required to keep copies of these documents that the employee provides, okay? If you decide to keep a copy for one employee, you have to keep it for all. The other issue, because this is a question I get from employers all the time, well, how do I know if the documents that the employee is giving me are fake? That's not your responsibility, right? Would it be great if you spent some time and just went online and decided to check out what an actual green card looks like? Sure, you can do that. But you're not required to be security experts and know exactly what the latest iteration of the green card or the employment authorization document looks like. It's enough for you to accept the document that the employee provided. Again, you have to make sure that you physically review those documents. You then hand the documents back to the employee. But when you're handing it back, you can then, like I said, choose either you want to keep the document, in which case you're going to have to keep it for every employee, or don't keep copies of the document, but make sure that you receive the documents, review them, make sure section 2 matches with the documents that they have provided. For those of you that have remote employees, this was already mentioned, and sorry, I'll come back to it. I just want to make sure you'll have this in mind because this is one of the main reasons for there to be errors in the I-9. If you are a remote employer, you will allow work from home, and you are not a part of E-Verify, then the recommendation is, depending on where the employee resides, depending on the length between you and wherever the employee is, either have the employee come to the office one time with their documents so you can review. But, if you're in Washington State and your employee is halfway across the world or halfway across the country, then you can find a local authorized agent. Typically, any notary agent, including the FedExes and the DHLs, have a notary. So you can enter into a contract with them and they will take responsibility for making sure that the documentation is correct. If you are a part of E-Verify, if you have opted to be a part of E-Verify for that location where the employee is going to be based, you have the option of doing this review virtually. You can do it via a Zoom call. They can literally hold it up to the camera. You can look at the documentation and you can put a note there that says this was done electronically via Zoom, and that's fine. That works. Okay, I think we've gone through this, but again, I want to make sure that you understand this. Like I said, it's one document from list A or one document from list B and one document from list C. You do not want to over document. So again, if you have a person that is a US citizen and that person provides you a copy of the birth certificate, a copy of the passport, and the social security number, my recommendation would be choose either the birth certificate or the passport. Both of those are list A documents. Choose one. You do not need more than that. You do not need to document more than that. Okay, it could become over documentation, which according to labor laws in certain states might be an issue with respect to discrimination against US citizens because you're asking them to provide more documentation and you want to avoid that. Okay. The other big issue with Section 2, again, as I mentioned earlier, is this failure by HR or by the owner, if you are a very small employer, pardon me, to complete the certification within the first 3 days of employment. Okay, you want to make sure that you're doing that. Receipt rule. I suspect most of you don't need this. I decided to put this just in case some of you have foreign national employees that are on various receipts, like an employment authorization card. So let's say you have an employee that is the spouse of someone that is in the US on an H-1B, which is a work visa. That person is eligible to continue to work, even if the card, let's say the employment authorization card expires July 1, but this person has applied for an extension with USCIS, with immigration. That extension was filed before July 1, and now they have a receipt from immigration saying, yes, we have received your application for extension. That receipt will generally also have wording in that receipt, which says your underlying work authorization has been extended by anywhere from 350 days to some now say 500 days, right? So that is what the receipt rule refers to. So if you have one of those employees and the card itself has expired, but they have a receipt to show I filed the application on time with USCIS, here's my receipt. It says I have the authority to work while this is pending, you can use that receipt number, and that you can use that receipt number as an I-9 document. That generally goes into a list B document, but you can use it. Again, if you have questions, feel free to reach out to me as a resource or speak to your attorney, but that is absolutely something that you can do. Again, I suspect most of you would not need it, but I decided to put it in here just in case you do. Receipts showing that a person has applied for an initial grant of employment authorization is not acceptable. Also, this gets a little complicated because, for example, if you have applied for an extension of your work authorization and you are on H-1B status, then you get employment authorization, automatic extension. But if you are on DACA, for example, deferred action for childhood arrivals, you have a DACA employee, and that employee's current work authorization expires July 1, and they have not received a new document. They have not received the actual physical card in hand. Unfortunately, automatic authorization automatic extension of the work permit does not apply to applicants that are on DACA. So every time you have this situation where you have an employee with a work authorization that has expired, but they're telling you that they can continue to work, speak to an attorney. Again, like I said, this is why it's important that you have some sort of a tickler system that's at least a 30 to 45 day notification to you to say, hey, there's this issue coming up. I would make sure that you have that tickler system set up somehow so you get notification, and then you can reach out to council, reach out either to nonprofits, reach out to me. Like I said, I'm happy to be a resource if you need it, but that's one issue that you really want to stay on top of because that becomes a violation of the I-9 if there is an audit. Okay. Again, I don't know if you have foreign students, maybe you have some interns that are working with you, depending on your business. Maybe you have some foreign students that are interns working with you. There are specific requirements for foreign students. Foreign students, actually, everybody in the United States that is not a US citizen, including green card holders. So green card holders and anybody on a visa is required to have a valid passport at all times. You cannot use an expired passport for purposes of I-9. Expired passports don't actually count for anything. So all immigrants in the US that are not US citizens are required to have a non-expired passport, a valid passport at all times. That is true for students as well, particularly for students. Students in the United States, even if they have temporary work status, will still be on Form I-20, which is the SEVIS record, which basically recognize their status as students and as them being in good standing and still enrolled in school or in university or their program. A Form I-94 is basically arrival departure record into the United States. It's your arrival record into the United States. There is a unique number that is assigned to each person when they come into the US that will have the duration of status, which means how long is this immigration status valid for. For students, that's going to say DS, which is duration of status, which generally means as long as the student is in school and is valid and is enrolled in classes and the university knows that they are enrolled in classes and they are in good standing, they are in status, meaning that they can work as long as they don't do anything to mess with that status and that status is not taken away. But those are the documents you will typically need to collect from students. Again, I don't suspect that many of you will have these concerns. I'm just putting these in here for the sake of being thorough because of everything that we're going through right now. The J1 exchange visitor is similar to the F1 students. This is for foreign nationals that have been admitted to the United States as part of a program of training or study. Some of the times, these can include professors, researchers at universities, and it can also include doctors. Especially in Washington State, there are a number of J1 researchers at all public universities and private universities, and we also have a lot of teaching hospitals or research hospitals in Washington State. So it's not uncommon that you would find a lot of doctors or physicians on J1 program. Okay, this is something that has come up during the first Trump administration, not to say that it doesn't come up otherwise, but it seems to come up particularly during, seems to have come up particularly during Trump administration 1.0 and certainly now. At some point, you may find yourself in a situation where you have an employee come up to you and say, oh, hey, by the way, I have a new employment authorization. This actually has a completely new ID. There's a new name, there's a new date of birth, but this one is a green card, whereas previously you were also given a green card, but all of a sudden the name has changed, but the picture is the same. You cannot ask any questions about what happened to bring that about, right? As an employer, you cannot have affirmative knowledge of an employee's legal status. That's one thing. But if an employee all of a sudden comes to you and says, well, I went through some immigration procedure and now I have a new identity, you are required to update that identity via a new Form I-9. So what you do is you basically include all of the new information that the employee has provided, including List A, List B, or List C documents. My recommendation to all employers, is that you then write a note, a contemporaneous note. You just type it up or write it by hand and say, on this date, this employee came to me, provided me these new documents, and I have completed the Form I-9 based on the information that they provided. You can ask the employee to countersign that document, right? The employee can say, yes, I agree, this is what I did. But you should typically keep that copy, again, stapled to the original I-9, along with your explanation, but you do not get to ask questions about how is that possible? When did this happen? Why did this happen? Asking those questions increases the risk substantially, depending on on state law, increases the risk of you being potentially charged with harassment or discrimination, and you don't want that to happen. So just accept what they give you, record it, put it in an email, to note to yourself, put in a memo, put it in the form. All right. So same thing again. Now, if somebody got married, typically they will be issued state identification. So just make sure that you have that. Any employee that has a name change should be advised to go to Social Security Administration and have that name change recorded with SSA so that you don't end up with a Social Security mismatch letter, which is a different issue that will come up. For those of you that use E-Verify, having two different names and not informing Social Security means you're going to get stuck with what's called a temporary non-confirmation. When you put in the information through E-Verify, you'll receive a TCN, which means you cannot go any further. So make sure your employee is aware of that. Okay. Correcting errors on Form I-9s. There are two types of errors that will occur on Form I-9s. One is what is considered to be technical errors, which is the ones that we covered earlier, like missing second last name, missing date of birth, wrong date of birth. If you are correcting those, you're required to just basically put one single line, strike through, date, and initial. Section 1 errors can only be completed by the employee. But for example, if they are completing the I-9 and you are counter-checking the documentation and you realize that the birth date has been mixed up, you can ask them to correct it immediately, right? But Section 1 can only be corrected by the employee. Whether the employee is correcting it or whether you are correcting it, you cannot use whiteouts. You cannot go squiggly lines all over the thing. Just one single strike through, date and initial. That's all you need to do. Retaining copies. Again, I've already covered this. You're not required to retain copies of the list A, B, or C document. If you choose to retain for one, you need to retain for all. For companies that participate in E-Verify and photo matching, when somebody provides a document used as a part of photo matching, you can retain a copy of the document and attach it to the I-9. Collecting copies of the document. So let's say somebody comes in with, a list B, a list C document. You can't just make a copy of it and say, okay, that's it, we're done. You need to complete the I-9 form, right? One does not substitute for the other. We've covered remote employees already. Sorry, I should have gone in order, but I tend to skip ahead sometimes. California-based employees, to the extent that you have employees in California, if you are using an authorized representative, ideally, you want to use an attorney to do this because California has very specific rules about the amount of training that that person is required to have received before they can act as an authorized representative. So if you have employees that are going to be working remotely from California, pay extra attention to what the state of California requires for authorized representatives. But otherwise, like I said, you can either have them come into your office as a one-time situation, or you can have them go to an authorized representative, which is either somebody in the same city that you have a relationship with, maybe you have a local office there, or if you don't know anybody there, then literally a FedEx, DHL, some form of a notary public in that state, in that city. As long as you can show that there is a relationship there between you and that entity, you're fine. Okay. Right now, there is a lot of issue with the sudden status expiration. So I don't know if if all of you are following what's happening in immigration, but this administration has recently decided to not extend parole for Venezuelans and a couple of other individuals, right? What that means is those people who had employment authorization no longer have it. And so you have to make sure about when that status ends, because if that status ends, they are no longer eligible for employment authorization, which means they must be terminated and can no longer work, okay? Re-verification. A non-citizen and a lawful permanent resident never needs to be re-verified. The lawful permanent resident card is generally valid for 2 years, for 10 years. Sometimes it's valid for 2 years if the person received it based on marriage to a US citizen. But either way, the permanent resident card expires. Permanent resident status does not expire. It has to be taken away from you, or you have to affirmatively give it up. Therefore, you never need to re-verify a US citizen or a lawful permanent resident or a green card holder. Anybody else that is in the US on some form of work authorization, anybody that's applied for asylum and is going to be receiving multiple employment authorizations, those are individuals that you would have to re-verify once their employment authorization expires or before their employment authorization expires. If the employee is rehired within 3 years of the date that the Form I-9 was originally completed, you can either choose, depending on your office protocol, to classify that employee as a new employee, which means you need to complete a whole new I-9, or a rehire, which means you only need to complete Section 3, which is the re-verification of the Form I-9. You don't need to have them do the whole thing all over again, okay? But you have that option. Okay, I think we've gone through independent contractors and interns. Basically, independent contractors do not need to complete a Form I-9. Certain interns, if they are going to be paid, yes, they need to complete a Form I-9. E-Verify you can opt into. It is not required. The administration is moving steadily, I think, to a point, and it's not just this administration, I think government in general in the US is moving to a point at which all employers will be required to sign up for E-Verify, but right now it is optional. You are not required to. The I-9 process does not substitute for E-Verify, and E-Verify does not substitute for I-9. You do not get to choose between one or the other. If you are an E-Verified company, you still have to complete the I-9. If you are an I-9 company, if you are an employer in the US, you have to complete an I-9. You may not need to complete E-Verify if you have not opted into the program, okay? But we've covered the tentative non-confirmation. All right, so again, using E-Verify, for those of you that have opted to use E-Verify, you need to complete I-9 and E-Verify. The biggest advantage of E-Verify was during COVID, you could use remote verification. You could use Zoom, literally, to do the verification for the employees. You still have the ability to do that if you are E-Verified, right? But E-Verify also has this tentative non-confirmation issue, which is so when you're completing E-Verify, could whoever's on the line please mute yourself?
Yeah, and we will do it on our end.
Okay, thank you.
Sorry.
So the tentative non-confirmation.
I'm sorry, Vanessa. You need to go back. You accidentally muted the speaker. I'm sorry, Kripa, could you go back to this section?
Yeah, sure. All right, so if you are using E-Verify, what happens is you go onto this portal, right? The government portal, you put in the employee's name, you put in the date of birth, you put in the social security. The benefit of using E-Verify is you will have almost instantaneous approval, saying, yes, you can go forward, this employee has a valid social security number. Or you will receive something called a tentative non-confirmation, which says, we're unable to verify this employee's social security number. And it may be, again, because the employee may have gotten married, may have had a name change, may have had something happen in their personal lives, just decided to change their names. Maybe they went through transition. Social Security has not yet been informed, right? So that's why just because you get a TCN, TNC, or a Social Security mismatch, you are not allowed to terminate an employee solely on the basis of a tentative non-confirmation or a Social Security no match. There is a separate procedure that employers have to abide by to give the employee time to show that they have gone to Social Security, they have tried to get this sorted out, right? So make sure that that's something you're keeping in mind. Just because you get a tentative non-confirmation, a TNC, does not give you the right to automatically fire the employee or to rescind any offer of employment you may have made, right? The Social Security no match happens with the I-9 paper or the electronic version of the I-9, but that generally will come in once you do payroll, right? Once payroll goes through and you do your payroll taxes for the state, then you may get a letter saying, by the way, we weren't able to clarify this employee Social Security number. So that's what I mean by a delay in terms of when that happens. Again, like I said, you cannot fire an employee. The employee has to be told that this issue occurred, and they need to be told exactly what they have to do. We provide our employers with a sample letter that they need to provide to the employee, but just understand that the employee has rights there. They essentially go to Social Security and do what they need to do to make sure that the Social Security number is correctly verified. Okay, the retention requirements for I-9. You are required to keep copies of your I-9. Either paper versions or electronic versions does not matter, but you are required to complete the I-9 and then to keep copies of it. You can complete or retain forms in an electronic generation or storage system for as long as that system has controls to ensure that not everybody in the office has the right to access it, right? So if you're using some sort of an electronic program, it has to be restricted only to HR or the employer or the person that is otherwise responsible for I-9s. It cannot be something that is on a shared drive folder for the entire office to review, because then that runs into sometimes HIPAA, but certainly privacy rules, okay? How long are you required to keep a Form I-9? So for each person you hire, you are required to maintain an I-9. If that person worked for less than 2 years, you have to retain the Form I-9 for 3 years after the date of employment, okay? After the first date of employment. If they worked for more than 2 years, then you have to retain the Form I-9 for 1 year after the date that they stopped working for you, whichever started working for you, whichever ends later, right? Whatever the later date is. So it's either 3 years after the date of hire or 1 year after the date of employment. The reason you want to purge or you want to not, and when I say purge, it doesn't mean go ahead and shred, right? You might want to put it in an offsite location somewhere, but not at the office, if that's what you want to do. But the reason you want to purge I-9 documents is, one, storage issues, but two, if USCIS decides or Department of Homeland Security decides that they want to do an audit, you are not required to provide Forms I-9 for employees that fall under that exception. Let's say they no longer work with the company. You can reasonably and perfectly legally not provide those I-9s to Department of Homeland Security. The reason you want to do that is really to limit your liability, right? So let's say you've held on to an I-9 for 7 years and really you only needed to hold on to it for 3 years, but those I-9s that you held on to for 7 years are the ones that have most of the errors. You're looking at a fine. It does not matter that you were no longer required to maintain them. You maintain them. HSI can see that there is a pattern or practice of errors on those forms. You can still be charged. There are ways that you may be able to ask for mitigation or for consideration and ask for a reduction in the fines that you will be assessed. But it is best to just have a proper policy to maintain, and then also to what I call purge, or to get rid of old I-9s that you're no longer required to maintain, okay? There are very specific documents for those of you that may want to retain copies of I-9s on microfilm or microfiche. I will leave this for you to review at a later date, but just understand that if this is what you're going to do, that there are specific requirements that you have to meet. There was a prior session that I did on I-9 audit trends, and so this is what that's referring to. Again, when I say this administration is very big on enforcement, this is what I mean. The last Trump administration, we saw a 375% increase in I-9 audits. We expect that same thing to happen again this time around, right? This time around, it's a lot worse, because here are your fines. It has jumped from 288 to 2,861 for paperwork violations. There are significant jumps all across the board, and these new fines went into effect January 2nd, 2025. Right? There is a reason we are doing this, and there is a reason WSMA wants to make sure all of you have access to this information, is because we want to make sure that our employers, whether you're big or small, you're able to operate and you're able to continue to do the amazing, awesome work that you do, right? You want to be prepared for an audit, both from immigration, but you also want to try to see if there is a way that you can learn to do an audit yourself. I am a big proponent of doing self-audits by employers, depending again on the size of your company and how often you onboard or fire people, how onboard, like how cyclical your work is. You may need to do this more often than others. Typically, if you're a small employer, you have standard number of employees. The same people have worked at your company between 5 and 30 years. Do it once and you're done. But if you're an agriculture, hospitality industry that tends to have a high turnover, you may very well need to do this once every 2 years, right? You'll be the best judge of that, of how often you need to do it. But there's definitely an audit protocol that you want to maintain. Here are some resources. The I-9 Central and the Handbook for Employers are both U.S. government resources. Anybody completing I-9, if this is a new role for you, you want to know more information, this is basically my go-to. This is the thing that most attorneys use as a resource ourselves, just because immigration changes things so often and we don't often get notice of it ourselves. But the Handbook for Employers will always have that. And then this also answers specific questions that you may have about something weird about a specific employee, right? This will probably have it. If you don't get those answers from I-9 Central or from the Handbook for Employers, again, feel free to use me as a resource. I'm happy to step in and help whenever possible. The Buchalter articles are really just resources and more client alerts that we put out earlier as soon as this administration was announced, actually, as soon as the elections happened. And this is really about getting ready for workplace raids. What are your rights as an employer? What should you think of? What should you do? Right? And then also best practices for I-9 compliance. I know it says 2024, but really, realistically, it carries over into 2025 as well. Probably will carry into 2026 as well. But these are resources for you to use. And then I think the last is just my information for you to have. As I said, feel free to use me as a resource. More than happy to help. I will again ask you to just refer back to the earlier session we did about I-9 audits, because I think that's sort of step 2 in this process, but I-9's compliance is step 1. All right. I know I went through a whole lot pretty quickly. Sorry for massive information dump, but you will have access to these slides so you can review at your own leisure, and I will make sure to answer questions with as much detail as I can. All right. Thank you all. Thank you for joining us. Lisa, thank you.
Thank you, Kripa, for that excellent presentation. I appreciate just how you unfolded all the details of this work, how to really understand the I-9 form. Thank you for answering the questions. Really helpful. I also want to thank the Small Business Resiliency Network and Ugo Nicolas with the Governor's Office of Regulatory Innovation and Assistance. We are grateful to all of you who joined us today. We will be putting together these questions. We will have Kripa answer those questions. They will be translated into Spanish as well. This video will be available for review in the future. We also just really want you to stay in touch with us as we do more workshops like this in the future. All right, thank you very much, everyone. Have a great afternoon.